It's a setback for the private airline as a single judge bench of the Madras High Court has ordered winding up of the private airline Spicejet. The official liquidator will have to take over the assets of the company. However, after a request was made by Spicejet's counsel, the single judge bench allowed a stay on the operation of the order for 3 weeks, subject to payment of $5 million by the private airline. The airline is free to file an appeal before the division bench, and the order, which was passed on the 6th of December, will come into effect after 21 days. Switzerland-based stock corporation Credit Suisse AG had sought winding up of Spicejet. The company holds the right to receive payments which were due to SR Technics. The company SR Technics deals with maintenance, repair and overhaul of aircraft engines and components. Credit Suisse AG had claimed inability on the part of Spicejet to pay a pending debt of $24 million. The High Court noted that Spicejet had accepted its liabilities in terms of an agreement entered between the two companies for a period of 10 years in 2011 by executing certificates of acceptance. The petition had maintained that winding up order was automatic in view of presumption of inability to pay debts as per the Companies Act, and had claimed that winding up of the airline can be stopped only if the debtor is able to show that the debt is not enforceable. This contention was accepted by the High Court's single judge bench. The High Court also noted that Spicejet knew it very well that SR Technics did not have DGCA's approval for aircraft maintenance in India, and despite this knowledge, the airline entered into business with this private company. Questioning the validity of unstamped bills of exchange raised by SR Technics, Spicejet had argued that when existence of debt cannot be proven in the absence of stamped documents, then the question of ability to pay the same would not arise. However, the High Court held that if there is an outstanding debt of more than rupees 500 and a written notice for clearing this debt is made but to no avail within 3 weeks period, the requirements of the law are fulfilled as far as the winding up proceedings of any company are concerned. It remains to be seen whether there would be any relief in the offing from the division bench when Spicejet files an appeal, since it's not the first time that the airline sector has witnessed such an adverse order from the judiciary. Many airlines in India are at various stages of the insolvency process, and Spicejet will have to prove its financials and will have to ensure that it provides due diligence. If at all, it has to gain some degree of relief as far as the liquidation order is concerned from the division bench of the High Court.